Number 21, the people of the state of New York versus Michael Johnson.
Good afternoon, Your Honors. My name is Denise Powell from the Appellate Advocates representing Michael Johnson in this appeal. The courts and scholars have
Ms.
long...
Powell, would you like to reserve any rebuttal time?
Yes, Your Honor. 2 minutes, please.
You may.
Thank you. Courts and scholars have long recognized that long post-arrest detention in a precinct, particularly when coupled with a series of interrogations and the deprivation of human substance.
So, in this particular case, when you say a series of interrogations, what do we actually know about how many and how long the interrogations were? What does the factual record show?
The factual record, the undisputed factual record, shows that at least 3 different interrogations occurred involving the Secret Service, Port Authority Police, and Suffolk County, and possibly auto crimes.
All right. So when you have a set of facts that involves all these different agencies, including federal agencies, agencies from a nearby but not exactly next door jurisdiction, how long do they have to actually do that before it becomes too long?
Well, the question is not as to the interrogations, not too long. The question is, what are the undisputed facts in this case? And they are that Mr. Johnson was arrested on May the 14th. He was held post-arrest in the precinct for approximately 30 hours. And within those 30 hours, he was interrogated by these 3.
What if there was testimony that during those 30 hours, he was given 3 meals, bathroom breaks, a cot? Maybe he was, it's hard to tell, but, maybe they brought him in one afternoon and the first interrogation didn't even occur till sometime the next day, so he had plenty of time to rest and so on and so forth. Given the same period of time, would that be enough to meet the people's burden of proof to show that it was a voluntary confession?
I have to make it absolutely clear that this case is not a Cheng-Ling. This is not a case where we are arguing that the proof showed that Mr. Johnson's statements were in fact involuntary. The question that this case presents to this court is, what is the minimum showing that the people must prove or come forward with when defense counsel raises a due process claim as to a statement? So when you have undisputed facts that a defendant is arrested.
So your view then is that this is not a mixed question of law and fact, and that it's really just about the sufficiency of whether or not they met their burden.
It's a question of what is the minimum showing.
So what would your rule be? I mean, if you had 1 meal, would that be enough? Should we have like a 1 meal rule?
No, it's not a question, Your Honor, about the number of meals. Or the question is...
So how isn't that a mixed question at that point?
It's not
because there was no showing?
There was no showing, Judge. That is the...
So the people have to come forward with what minimal showing?
When the undisputed facts show, again, in the context of a...
No, I know what the undisputed facts you're going to say show, but what would the people have to come forward with? I mean, because it's not going to be only in this case. So what would the people have to come forward and show?
The standard... First, we must at least acknowledge that it's the people's burden of proof beyond a reasonable doubt, and the standard is clear. It is based on a totality of the circumstances. It is not the ones that the people cherry-pick from.
But this, again, that sounds like a mixed question to me, because we have the facts here. You argue the key is voluntariness. So based on the facts that were presented in this hearing, the court found the statement was voluntary. So in order for us to undo that, there has to be an error of law. And if there's an error of law, we have to give guidance as to what would be the minimal showing that people would have to come forward with. And I'm still having trouble understanding what your rule would be.
minimum showing, again, when the undisputed facts show that the police arrest someone and detain that person post-arrest in a precinct, and there's a showing that he is subject to multiple sessions of interrogation, the people must, at a minimum, show the details of the defendant's confinement, which would
So
include.
if it had been one interrogation, just the detectives on this, would that have been sufficient showing? I mean, I'm not sure why the number of interrogators matters, or the number of agencies.
Well, it just so happens that in this case, there were
Well,
three.
I thought, counsel, going back to Jen, I thought the point in your briefs was that there's already, based on the evidence at the suppression hearing, something that suggests the conditions that would render any statement involuntary, the multiple interrogations, being held for over 24 hours between arrest and arraignment, that it went from night to night, so you're going overnight. In addition to the fact that the people failed, so they've got that evidence, they've
That's what we
failed,
have
I thought
here
this
as
was your
well.
point, that then they failed, though, to put forward evidence, because the officer either couldn't remember or didn't clarify in his statements during the suppression hearing, evidence that would tilt the other way, which we have recognized as evidence that would support that indeed the defendant's will was not overborne under those conditions. Like
Correct.
eating, drinking, sleeping, going to the bathroom. I thought that was the nature of your argument, not that this is a mixed question and we need to engage in a
not.
fact analysis.
Exactly, Your Honor. I am.
Let me ask this. You're claiming, in essence, as Judge Rivera outlined, a deprivation of necessities claim, right? Am I correct in that?
And there is no proof that.
No,
he was-
that's, my question is your claim that he was deprived of his necessities, the basic necessities, and therefore it wasn't a voluntary confession?
That's one,
statement.
that is one prong of
Let's-
the analysis.
I understand that. But that is a prong of your analysis.
That is a prong
So
of the analysis.
doesn't, let's just assume we agree on that. So then let's take it to the next step. Doesn't a deprivation of necessities claim in essence involve a weighing of factual matters? In other words, you wouldn't have a deprivation of necessities claim if the guy made a statement after 4 hours. It's because you have 25 to 30 hours, right?
Correct.
So the facts matter then. So then, if the facts matter, aren't you obliged in your claim to say, under these facts, we were deprived of necessities?
And Judge, as the record shows, defense counsel specifically alerted the people that this is my claim. He was held.
In the omnibus motion, you're saying
The
that?
omnibus motion, the claim was specifically identified, and counsel pursued a portion of that claim during the hearing. In the context.
It wasn't specific, it wasn't, it vaguely was mentioned in the omnibus hearing, it wasn't with the specificity that we're arguing it now or in the briefs, but I see what you're saying.
It couldn't be, I don't think, more clear. Counsel said, my client was held for more than 26 hours, and he was deprived of food, water, and sleep. It can't be more clear.
I
And when-
think I understand that argument and the fact that because there's nothing put forward by the people, that there's nothing to weigh because there's nothing.
Nothing there.
But that does lead me to the question of at what point does that burden come into play? In other words, if he's there for 2 hours, then we probably would agree that they don't need to put into any proof of bathroom, food, water, sleep, right? So at what point does
point-
that shift?
The point I would suggest, Your Honor, is when the police violate Section 14020 of the CPO. That is the point.
But
And
then
I just have-
again, then you want to turn that into a per se rule.
Well, it's not a per se rule in terms of,
And we've already
don't
said it's
feed, and then-
not.
Pardon?
And we've already said it's not.
It's that the length of time is not a per se rule. Once the period is exceeded, then the court must engage in a careful inquiry about what occurred. But I have to emphasize that this is not just about the deprivation of food and the people's failure to prove that this man was fed at the very least. There's also an absence of proof of what occurred in any single one of, it could have been just one interrogation, but in this case there were 3. And we have no idea what occurred during those interrogations. There's no evidence of whether or not he was threatened. There's no evidence, because the people failed to come forward with proof, as to whether or not any promises were made to him. There is no evidence that whether or not he talked about the Queen's case in those other interrogations. There's no evidence, because the people failed to prove it, that he was Mirandized. And in fact, the testimony at the suppression hearing supports the conclusion that he was not Mirandized, and yet the people failed to satisfy the Chapel Bethea
Thank you.
factors.
Counsel?
Good morning, good afternoon. May it please the Court. Nancy Fitzpatrick Talcott from the Office of Richard A. Brown, the District Attorney of Queens County. Initially, defendant did not argue below that there was a lack of evidence in the failure of the people to call other officers.
Counsel, what was the people's burden at that suppression hearing if there's no information, given the number of hours that the defendant is held in that interrogation room? There's no information about what Judge Fahey called the necessities that we have also identified in prior cases as important to consider.
The burden is to prove beyond a reasonable doubt the defendant's statement was voluntary. Now, the people are going to put forth evidence based in part on what the defendant posits. The defendant never posited...
No. But you put in evidence that you had him over 25 hours.
Yes,
so
and that
during
was
the course
warranted.
of 20, and we have said, during the course of that kind of time frame, one would expect that an individual has to go to the bathroom, needs rest, maybe wants to drink something or eat, so that their will is not overborne. Is that not part of your burden?
Yes, and that's
Okay,
just...
did you put in that information?
I would argue yes.
Okay, how did you do that?
Okay. Well, first, initially, whether the food, drink, or bathroom are relevant circumstances is certainly not indispensable to a finding of voluntariness. And this court itself has upheld a voluntary statement
No.
without a
Counsel,
That's
you
not
can
what she's
argue that
asking.
you don't have to do that, but I asked you a direct question related to your earlier response. You said the people did put in that kind of evidence at the suppression hearing. You may now wish to argue they didn't have to. That's fine. That can be your second point.
Okay.
But first tell me what they did put in.
I think that Detective Roberts made clear he checked on the defendant. It's reasonable to infer, and here's where the mixed question of law and fact, these inferences that can be drawn from the evidence presented present the mixed question of law and fact.
Reasonable to infer what? From the fact that...
That the defendant was taken care of, he was checked on.
So you're saying the fact that he was checked on, so in other words, the officer, opens the door, looks in, he's still alive, he's still breathing, whatever. That's enough from which we can infer that he's being taken care of?
Well, you also had, keep in mind, the defendant argued, contrary to their claim, that the people didn't present evidence of how the defendant was treated before Detective Roberts questioned him. In fact, we did submit evidence. The people submitted the Suffolk County decision regarding the Suffolk County interrogation. And in admitting that, the people noted that Detective Roberts didn't know what had occurred and whether he had been Mirandized. And the people noted there was no allegation that Suffolk acted improperly. And in fact, there was never an allegation, which is why this present claim is unpreserved, that any agency acted improperly or that any of that purported conduct tainted the statement at issue.
Well, there's an allegation in the omnibus motion, right, that specifically says food, sleep, et cetera, were deprived.
Right. I would argue that particular aspect was actually abandoned by the time the hearing came and after.
Well,
because what they focused...
Let's assume it wasn't abandoned, because
Okay.
what your burden is depends on what their claim is. If they claim you were beaten, there's a different burden. If they claim he wasn't Mirandized, you have a different burden. So here, your burden is necessities. How was that burden met?
by Detective Roberts' statement that he checked on him, and the Suffolk County decision indicates that not only was he Mirandized prior to that statement, but that that officer did in fact ask him if he needed a drink or wanted anything.
I see.
Now, there was absolutely no accusation, as the people pointed out, which was not refuted by the defendant in oral arguments after the hearing, that there was no allegation that Suffolk had acted improperly. In fact, she only submitted the decision because Detective Roberts had indicated, I wasn't there, I don't know if he was Mirandized. Interestingly,
What about the
court-
rest of the time, during the other two agency interrogations? What's the information about that?
There wasn't any.
So we don't know what else happened.
No, but
Do you
again,
know how long the Suffolk official interrogated the defendant?
the Suffolk statement indicates 7:30. Detective Roberts went in at 8:30, so at most an hour.
So the last one before the defendant
Yes.
makes the inculpatory statement.
Yes. And at the very least, also, had defendant raised a specific claim in the post-hearing, the people could have remedied it and sought to reopen the hearing. A decision hadn't been rendered. The court could have exercised
I'm
its
sorry,
discretion.
what's the specific claim? I'm sorry, what?
That something untoward or deceitful happened during these earlier interrogations that then tainted.
But you were aware about as
Statement.
Judge Fahey said, about the issue related to the food, drink, eat, rest, and you
Yes,
didn't put in any
that
information there,
that
right?
was argued summarily in the motion, and again,
But the people didn't submit any evidence on that,
No.
other than what you have said, that
right.
he goes in, checks on him, and we
Right.
should infer from that.
And the Suffolk decision makes note that that officer actually did testify, that he checked if he wanted drink, and I believe the defendant said no.
Could you spend, I'm sorry.
Let's say we are of the view that there aren't sufficient proofs here of the, provision of the necessities, or is what we're calling it. What's your fallback argument in terms of the totality of the circumstances? What are the other circumstances that would tend to show that this was voluntary?
Okay, and that's precisely what the appellate division found, that that Detective Roberts' failure to make note of what happened during the checks was not fatal. And again, there's record proof in this mixed question of law and fact that the other circumstances established the voluntariness of his statement.
Well, what are those other circumstances? That's what I'm asking you.
Okay, one,
Talking about totality of the circumstances,
Yes.
deprivation
Right.
of necessities is one. Let's talk about the others.
so we're going to look at both the characteristics of the accused and the details of the interrogation. The details of the interrogation. The delay was not unnecessary. Even unnecessary delay, as in Lynn, this statement can still be voluntary. But again, under 14020, the people have to, without unnecessary delay.
Yeah, but that doesn't go to voluntariness. That goes to the reasons for the delay.
Well, voluntariness, you have an experienced defendant here who's unlikely awestruck or intimidated by his custody. He's unlikely to be swayed by ordinary interrogation techniques. He's not subject to continuous interrogation between arrest and arraignment. In fact,
How do we know that?
because the first 18 hours, they're looking, they have to wait for BMW to open to determine where the key fobs are linked. They're putting together a photo array. There's just no indication that he was, and the other agencies don't come in until around 2 o'clock. So from 7 o'clock on his arrest until 2 o'clock, there's absolutely no indication. He was questioned. Detective Roberts went and checked on him, but he wasn't even there most of the time. He's not physically restrained. Detective Roberts testified to that. He made the statement after,
The Suffolk decision, does that suggest otherwise, perhaps?
suggest,
That maybe he was handcuffed?
well, Detective Roberts says while he was waiting, he wasn't handcuffed. The Suffolk decision does say, now keep in mind, those officers testified, they removed.
My point is, you can't use the Suffolk decision when it helps you and then ignore it when it hurts you.
No, but I think it's, when Detective Roberts was checking on him and while he was waiting, I don't think he was restrained. When officers are in there unarmed, they had checked their weapons, the Suffolk County thing, I think he was cuffed there for safety reasons. I think while he's waiting, he's not handcuffed at all times, and that's what Detective Roberts was indicating.
Wouldn't it help if the people affirmatively indicated what the circumstances of his confinement were?
Well, when Detective Roberts checked on him and questioned him, he wasn't restrained.
In that moment?
Right.
Right.
Or he said,
How
well,
about the rest of
he
the
actually
other
said
30
while he was
hours?
waiting. Well, in Suffolk, I think they did handcuff them because they had removed their guns,
So.
apparently
so-
for safety
but
reasons.
In other cases
Yes.
that we've actually reviewed, there has been very detailed information submitted by the people. These were the conditions in which we held him. And they laid it out. And then, if we look at it, we can, some of us might think that's okay, and some of us might think it's not, and that's clearly a mixed question. Okay, here, we're being asked to make an awful lot of inferences.
Well, we know that he wasn't questioned for the first 18 hours. There was no issue as to the propriety of the other
Okay, but
interrogation,
that
but then-
gets us back to the other part, is we don't know what was going on with him for those 18 hours. We have no idea where he was, what he had available to him. That's 18 hours. That's a pretty long time. We don't know when the last time he ate before they brought him in was, or the last time he slept, or the last time he went to the bathroom.
No, and again, I mean, that's just one factor to consider in the
Counsel?
totality.
Counsel,
Go ahead.
let's assume for a moment that the statement should have been suppressed. What's your argument as to whether that would be harmless error?
Oh, it was harmless. One, it was largely exculpatory, which also weighs in on the voluntariness. This wasn't a statement that the police put the words in his mouth. You have an incredibly strong, as the appellate division noted, identification by the victim. He had ample
Well, let me
opportunity.
stop you there. This is the identification. We have a number of cases here where he has a mask on, you can see his eyes, right?
You could see more than his eyes. He specifically said the mask, it's not even a mask, the face covering went from above his eyebrows below his nostrils. So he's
So it's like
actually
a
able
ski-
to
so
see.
let me stop you. It's like a ski mask, right?
I would say less, but I don't ski,
All
so.
right. So the eyes were visible, but the rest of the face wasn't. That's the identification. And the victim was, you had the victim, the wife, and two other witnesses, is that right?
Yes, but could I make one correction?
Sure.
His eyebrows, below his eyebrows, nose, cheekbones, and skin tone were visible.
I see.
Not just his eyes. It went from above here to here, so you could see all of this.
And
And
the
keep in
key
mind,
fob.
he's a retired police officer, perhaps trained more in observations and taking note of
You're
descriptions.
talking about the victim?
Yes.
Yes, yeah, I understand that.
He gave-
I understand what the identification information is, but it's not a clear face. That's the point of the weakness in the identification, as you will admit, is it's not a clear face. The other thing is they got two fobs that the guy had, right? Not one.
Right.
Two BMW fobs. One of them was this guy's car, was the victim's car.
Yes.
The other one wasn't. But of course, someone could have those fobs and be guilty of the robbery and not be guilty of the attempted murder.
Right, except that the victim identified him as the shooter.
Right.
Where was
And
the gun ultimately found?
the gun, the piece of the gun was ultimately found in the informant's house, who was a friend of the defendant.
It goes to the
Where
harmless
did
error.
he get
Right.
it, though? Didn't he get it from the?
He got it from the defendant's wife.
Defendant's
The
wife,
defendant's
okay.
wife had a
Well, that's
ring.
his testimony.
Yes.
Could I ask you to address the issue in the pro se brief about the late production of the Rosario material and the identity of Nichols, the informant?
Yes. In light of the threats and the evidence presented before the
But why
court,
wasn't that unfairly prejudicial for counsel to learn Father's Day in the afternoon, I guess, to get this Rosario material and learn the Friday before about the existence of this witness after having voir dired the jury and not ask the typical questions people ask about informants?
no, under CPL 24050, the court properly issued the order, and as we detail in our brief with the actual days and weeks, defendant received all the discovery material in ample time to use it effectively. And the record reflects that he did.
Right, no, putting aside that the protective order, not at issue in that way, that, yes, let's assume the protective order had some basis and so forth, but once counsel is made aware of this witness, and now, as Judge Wilson has pointed out, didn't have an opportunity to ask questions of the jurors that counsel might have if they had been aware of this witness. In addition to that, gets no extra time. Did counsel get any extra time to prepare as material was being turned over about this witness?
Well, I don't recall that he asked for extra time once it was turned over, and it was provided to defendant in time to investigate and use at trial. It was 10 days before opening, a week before, 10 days before cross, a week before Nichols even testified.
When is the last
informed.
time, when is the last time that the people turned over materials about that witness to defense counsel? Is it 10 days before?
I think 3 days before, the prosecutor turned over the federal plea.
3 days before direct, 3 days before?
3 days before cross.
Thank you.
And wasn't there material being turned over during the direct of the witness?
I think there was material turned over before and during.
Thank you, counsel. Counsel?
Just a couple of things, Your Honor. My adversary made reference to the Suffolk County decision. That decision was rejected by the suppression court as evidence, and for good reason. The decision itself is made part of the appendix, and the court, as the court noted, and also as counsel noted, there was no reference in the body of the decision as to when that Suffolk County statement was obtained by Suffolk County. So we cannot draw the conclusion or inference that the Suffolk County, although they may have interrogated him prior to Detective Roberts' interrogation, that in fact the decision that that the people turned over during the argument, it in fact is in reference to a statement that was obtained before Detective Roberts actually interrogated Mr. Johnson.
So you're saying that's a determination about the Suffolk interrogation has nothing to do with whether or not the statement to Roberts is voluntary? Is that what you're trying to say? In addition to it's not in the record because the judge didn't accept it.
Well, the court rejected it as substantive evidence as to whether or not the Suffolk County police officers actually obtained a statement from my guy prior to Detective Roberts. There was an encounter prior to Detective Roberts, but this Suffolk County decision may very well be in reference to a statement that they obtained after Detective Roberts. So even though it makes reference to, whether or not he was fed or whatever, that could very well be in reference to a time period after Detective Roberts interrogated my client.
Thank you, counsel.